All right, everybody, it's 10 o'clock. Let's get started. We are going to be talking today about Farbar, Nabor, and the contracts in the wake of Hurricane Ian. I really hope everybody is safe. We are very fortunate here. We had no flooding and no damage, just no internet. So I'm working off of a hotspot, and I'm working off of a laptop, so my normal multiple screens are not going to be working. We'll do the best we can, and we're going to go through this quickly. I'm sure everyone's got stuff they've got to do in recovery. So, of course, I'm an attorney, but I'm not creating an attorney-client relationship. We need to get together if you have specific questions about your clients, but you can always ask in the chat or on just shout them out as we go through this Zoom today. A little bit about me, of course. Been doing this since 2003, and I am on the Nabor Legal Resources Committee. We're going to be putting out some Nabor information here over the next few days. So stay tuned for that as well. Oh, please mute yourself if you are just joining. Okay, we're going to review the Farbar contract provisions regarding force majeure. We're going to review the Nabor contract provisions regarding casualty event. There is no force majeure in Nabor. And we are going to look at a couple of other legal doctrines. And then we are going to take as many questions as people have. I'll stay on as long as we need. So some opening thoughts. Insurance started again with Citizens on September 30th. I was told from Citizens folks they started binding again on Friday after the storm passed. No force majeure clause in the Nabor contract, so we'll talk about how to deal with that. And then if we lose connection, just jump right back on, because I'm on a hotspot and I'll be able to get right back on and just may kick us off here. So we'll do the best we can. Okay. Okay, I'm gonna share the screen here. Give me a second. I'm just switching over to the as-is contract. Okay, so this is the as-is contract for Farbar. The provisions that we're to go over are the same in the Farbar and as-is and regular, except for a few little differences related to as-is inspections. First of all, in Farbar, they have a force majeure clause, and it is one of the two outlined extensions that are automatic in the contract. You can see here, section 5 of the Farbar contract. If an event constituting force majeure causes services essential for closing to be unavailable, including the unavailable utilities or insurance for hazard, wind, flood, or homeowners insurance, then the closing date is extended as provided in standard G. So we're going to skip down to standard G and then come back to some of this other stuff. So standard G outlines a force majeure event under FAR-BAR. It's a very detailed provision, but basically the buyer and the seller are not required to exercise or perform their rights or obligations during the force majeure event. And that is this test is it's so long as performance or non-performance of the right or obligation or the availability of services, insurance, or required approvals is disrupted, delayed, or prevented by the force majeure. Of course, force majeure includes hurricanes. And then you get a reasonable time up to 7 days after the force majeure event no longer prevents performance. So my understanding of this sentence is that once the hurricane passes, there still may be other events preventing performance, like no power, no internet, things like that. But as those services come back online, then you're going to have to perform. And since in this particular case for Hurricane Ian, if the event event prevents performance for more than 30 days, which I don't think is going to be the case, you could terminate the contract. Let me also just say at this time, these contracts, the FAR-BAR and the Nabor contracts, are designed to keep the deal together. So they're going to be difficult to get out of. I know a lot of people are calling, how do I terminate my contract? I don't want to buy this property and I don't want to lose my deposit. And the reality on FAR-BAR and Nabor is that these contracts are designed to keep the deal together. They have provisions that make it so that in the event of a force majeure, you can still move forward with your closing. It's just going to be delayed as opposed to canceled. Few other things I want to point out in this contract. So the buyer gets a walkthrough inspection. They get to confirm that all items of personal property are there, and the property has been maintained as required by the maintenance provision. But I want to point out under this contract, except for ordinary wear and tear and casualty loss, the seller has to maintain the property, including the lawn and shrubbery in the pool. So except for casualty loss, what does that mean? Well, there's another provision of the FAR-BAR contract. If I go further down, risk of loss. And that defines casualty loss as the property being damaged by fire or other casualty, which we can assume includes a hurricane. And then what this contract does is it prevents, or the maximum exposure under the FAR-BAR contract for a seller is 1.5% of the purchase price for a casualty loss. So if the restoration is not completed as of closing, you escrow a sum of 125% to complete the restoration, but you don't go over 1.5% of the purchase price. So essentially, in no event would the seller be exposed to more than 1.5% of the purchase price, unless, of course, the seller agrees to do more to keep the deal together, because the buyer can either take the property as is if the damage exceeds 1.5% of the purchase price, or they can get their deposit back and terminate the contract. Be careful when you are figuring out what your casualty loss is under the contract, because this contract limits the damages from landscaping to cost of pruning and removal. You don't have to replace landscaping. So if somebody lost one of those royal palms or something, some large piece of landscaping, they would not have to replace it. They simply have to prune and remove the damaged items. Okay, any questions about the FAR-BAR contract before I move on to the Nabor contract? Let's see. Nothing in the chat. Okay. So.
I have a question.
Yes, Nanette.
So you're saying, because I have this exact situation right now under this contract, there was a lot of trees that were not so much, there was one huge palm that was destroyed, broken off or whatever, but then there's a lot that are just stripped, and they don't look the same condition. You're saying they don't even have to replace the one that was destroyed? Like they don't need to give you that amount of money to replace that tree?
So the most the seller is going to be out is 1.5% of the purchase price. I read this sentence that I've highlighted here to say that with regard to tree damage, the sole obligation of the seller is the cost of pruning and removal. So for your example, the tree that was totally damaged, that's a large tree, probably depending on the purchase price of the property, could exceed 1.5%. First thing you have to look at is what is the seller's obligation for tree damage, and that's just the removal and the pruning. It does not require replacement of that lost tree.
Yeah, okay, so for instance, this situation, there's other damage, like the pool cage fell down, so the 1.5% is going to go over already. And my people are very nervous about staying in general. So
you have the buyers or the sellers?
I have the buyer.
So the buyer can either take as is and get 1.5%, or they can terminate.
Okay, so even if the people agree that they will put the total amount of money back in to replace the pool cage and replace the tree, we still have the option if we want to walk away and not take the replacement if it goes over the 1.5%.
Yeah, if you see here, I didn't highlight that part, but it says seller shall pay the actual cost not in excess of 1.5% of the purchase price.
Okay.
So the seller is obligated to give 1.5%. But they're not obligated to do anything over 1.5% without a separate amendment or agreement that we write up that changes the nature of the contract. So
if the sellers were willing to pay above the 1.5% to fix everything to keep the deal together, and my people still didn't want to do it, they have the right to get their deposit back.
That's how I read this sentence.
That's how I thought you said. Okay, perfect. Thank you.
You're very welcome. Okay, we have a couple of questions in the chat. So Noella, yes, it used to be 14 days in the old version of FARBAR. It's now 7 for force majeure. So that's a change from I think 2013 version of the contract to the 2000 what's the date on this one? The 21 version is 7 down to 14 down to 7. Maria, can you explain the termination for buyer again? Maria, if the damage under FARBAR exceeds 1.5%, buyer can terminate and walk away and get their deposit back. Okay, Andy is asking, if the tree is destroyed, do you think the seller has to remove the stump? It's just pruning and removal, Andy. So yes, the stump would need to be removed as part of the removal, I would think. And Delia says, does that apply to cash buys? Yes, this applies to any deal written on the FARBAR contract, Delia. Okay, FARBAR questions. Let's move on to Nabor. So the Nabor contract does not contain a force majeure clause at all. What it contains is a couple of provisions related to casualty and inspections, but I want to start off on section 6 of the Nabor contract. A lot of questions because everybody knows post-hurricane, there's going to be special assessments. Who's responsible for special assessments under Nabor? Under Nabor, the special assessments go to the seller if it's the 3-part test for the identity of the lien or the property subject to the lien and the amount of the assessment have been determined prior to contracting. Anything after contracting goes to the buyer. So all of you people that were in contract on September 27th, if you expect a special assessment to come up, your buyer is going to pay that special assessment. Okay. Moving right along. So under the Nabor contract, the seller has a maintenance obligation. And you can see here, the seller shall maintain the property, including the landscaping. Nanette, I'll get to the FAR bar assessments in a minute. I've got the rider to show you guys. But under Nabor, the seller maintains the property, including the landscaping, as the condition that exists on the effective date, except for ordinary wear and tear and any remedial action. And the scope of the maintenance obligation does not extend. Oh, this is important for Nabor and FAR bar. I forgot to mention this under FAR bar. The scope of the maintenance obligation does not apply to the association. It applies only to the unit. So if you're a condo, it's the condo itself, the interior of the condo, not the building. So if the roof got blown off your 3-story condo and you're trying to sell a 3rd floor unit, get with your association, because they're going to fix the roof and you're going to fix the interior of the condo. If you're in a homeowners association and the gate was destroyed or doesn't work, or the landscaping was totally wrecked, like for those of you that have seen some of these associations, the landscaping's pretty beat up right now. You cannot back out of the contract or have maintenance requirements under Nabor or FAR bar for association property. So the buyer gets a walkthrough inspection to determine that the remedial action is completed, that everything's been removed from the property, that the maintenance obligation has been held up. That seller's maintenance obligation is detailed below, and I will go over that in a moment, or I'm sorry, above. And it is, basically that the property is maintained as is, except for wear and tear. And if it's not, then you either provide a credit or do 200% estimate of the estimated cost to repair the items go into escrow. That's 200. So you have to get a repair estimate over there as quickly as possible. Okay. Risk of loss under Nabor is at the seller's sole risk and expense. So the seller's got to put the property back together under Nabor with some limitations. One of the limitations relates to landscaping. So under Nabor, the landscaping, if there's damage by casualty, it's 1% of the purchase price. So in Nabor, that giant tree may have to be replaced if possible, but it says to the extent reasonably practical based on the availability of substantially equivalent replacement landscaping. So if you've got a 50-foot royal palm that came down, it's not getting replaced. Even if it's a $10 million property and 1% of the purchase price is $100,000, and that tree is not getting replaced because it's not going to be available. They just, finding a 50-foot royal palm is going to be almost impossible. So there's going to be a lot of give and take as we go through this contract. People from Irma, I remember, it was a big deal about landscaping and getting the landscaping back. And basically, you have to do the best you can and make the property look as best as possible. But the buyer is probably going to have to accept less landscaping under both contracts. So let's talk about insurance. I got a couple of emails about insurance. Under the Nabor contract, if it's the casualty, which by the way includes the hurricane, if as a result of the casualty, the buyer is unable to get insurance at a reasonable rate, or if services essential for closing are not available by the closing date as a result of the casualty, then the buyer can delay the closing until up to 5 days after coverage becomes available and services essential for closing are restored. So citizens started writing on the 30th. So technically, today is the 5th. That would be today is the last day when the buyers have to start performing and get their insurance going again. But it's got to be at a reasonable rate. What is a reasonable rate? Well, that's for a judge and a jury to decide. And we want to avoid judges and jury. Octavia, I see your question. A reasonable rate. I'm not sure the best way to say what a reasonable rate is. It's so expensive, and the insurance market was already really bad prior to Ian coming through. I can imagine it's only going to get worse. Reasonableness is the eye of the beholder. So again, you have to work together with all the parties to keep the deal moving towards closing. The buyer should be in contact with multiple insurance companies. If they've got to buy them through Citizens, it's going to be expensive, but I'm not sure that that's going to be unreasonable given the circumstances. And I was unable to find case law that defined reasonable rate for insurance. So it's going to be basically a negotiation. Okay, if the property is rendered unfit for habitation or totally uninsurable, then the buyer or seller may terminate the contract after within 5 days after receipt of documentation saying the property is uninhabitable. So if you are a buyer trying to get out of the contract, which I hope we don't have too many of those, if you're a buyer trying to get out of the contract and you get a government agency to say the property is uninhabitable, then you could get out of the contract, or if you cannot get insurance based on Citizens guidelines. And I will say this, we mentioned Citizens in the contract, so it's probably going to be the standard. I know a couple of other attorneys from Nabor are on the call. If they have a different take on that, let me know. But I'm pretty sure that a judge would say that Citizens listed is stated in the contract, so it's going to be the standard. So if you can get Citizens, you're probably going to have to close. I'm in the middle of litigation, is just now getting started fast on a case where another attorney has a buyer and they think that this extreme weather condition provision will protect their buyer who wants to terminate because coverage wasn't available prior to the hurricane coming, and they're relying on this language here, pending or threatened hurricane. Well, in my opinion, that has already passed and is no longer applicable. This was prior to the hurricane coming through, not when Naples and Florida were in the box and we couldn't get insurance. We put this provision in there to protect in that situation. But in my opinion, the contract provision that controls now is this provision: availability of insurance and services essential for closing. So be prepared for possible litigation there as insurance rates continue to rise. We have a question, Lily. Lender is requiring reinspection of the property before closing. Lily, your question is that the lender wants reinspection and there's a 7-day force majeure. The reinspection within 7 days and lender requires repairs but cannot be done. If the buyer can't get, you must be under FAR-bar, Lily, because if the 7 day, start with the 7-day force majeure. But if the lender won't lend in FAR-bar, you've got another situation because you've got to look to your financing provision. And I have to think about that, Lily, and come back to you on how that would apply. Valentina is asking, what if the property is flooded and seller files flood insurance claims? Buyers were financing with Wells Fargo on an as-is contract. So if you've got pending insurance claims, you're not going to be able to get insurance. Under Nabor, I would argue that you can terminate the contract. FAR-bar is less clear, Valentina. So you didn't say what kind of contract you had, but under Nabor, I would say that if you can't get insurance, then you can terminate. All right, let me pull up the rider. One second, everybody. Just going to pull up the rider to the contract for those of you that have condos. This is important. Okay, share screen. Okay, so FAR-bar, switching back to FAR-bar. Okay, right, condominium rider A to the rider A to the FAR-bar contract has a couple of provisions that we're going to deal with. Special assessments. Buyer pays any amounts due after the closing date. So, you know, if you've got if you just went under contract and you're not closed yet, and special assessments get put up by the board, or if there's emergency meeting for your condominium association, then the seller pays amounts due before the closing and the buyer pays after closing. And then, okay, again, under FAR, the inspection and repair rights that the seller, the seller's obligation to repair things does not extend to the common elements, limited common elements, or any other part of the condominium property unless the seller is otherwise responsible. I read that to mean that if you've got a boathouse or a cabana or a dock and it's a limited common element, you need to check the condominium documents to determine who's going to be responsible for those repairs. And unless the seller is responsible in the condominium documents, then the association is going to be responsible, and it would not be an item that would need to be repaired prior to closing or escrowed. And remember, we do 125% escrow in FAR. Okay. Okay, this is rider B for homeowner associations. That's different than condo associations, of course. And this one for special assessments that are levied by the association as of the effective date, or levied after the effective date but prior to the close date and due in full prior to the closing date, then the seller pays. If there are assessments that could be due after the closing date, if they're in installments, then you pick the box. You gotta check your contract as to who's going to pay that. Kimberly is asking, what about the beach clubs and amenities are gone? Can the buyer get out? No, they cannot, Kim. The Nabor contract specifically says, and I will show it to you, specifically says that association property is excluded from the seller's obligations, wherever that is in here. It's in here. I know it is. I have it highlighted somewhere. Here it is. The scope of the seller's maintenance obligation does not include any item which the seller has no means to repair or replacement obligation under the governing documents. So Kim, they cannot get out of it if the beach club is gone. I'm hoping you're not up in Bonita Bay, because that was pretty bad. Nanette is asking, FAR, does the assessment responsibility stay the same if it's a neighborhood, single family home and not a condo? Nanette, I just covered that. No, it's not the same. You got to check your contract for the box checked for the homeowner association, and the condo association is laid out specifically in the contract. Okay. Other questions that people have? Wade says it's a FAR. What was your question? What if the cash buyer who's out of state wants to re-inspect the property and get it go? Wade, you're entitled to a walkthrough inspection the day of or day before closing. And I would say that, again, we need to be reasonable. We need to tell our customers to be reasonable. But if you need a re-inspection, I would say we should try to get those done contractually. You get a walkthrough, but I don't think that's very fair. Okay, there are two other legal doctrines that I want to address that you're probably going to hear about, that I don't think really apply, but I think you need to at least hear about them. First off is the doctrine of impracticability, and I assume everybody knows doctrine is just fancy lawyer speak for law. Impracticability, when it is objectively impossible for anyone to perform the duties of the contract, you can use the defense of impossibility or impracticability to excuse that performance. But the test is neither party could have known about the performance, the risk of impossibility. And basically, if acts of God are not necessarily foreseeable at the inception of the agreement, but we live in Southwest Florida in hurricane season, you're going to need a really sympathetic judge and jury, and it's going to be really expensive and take a long time to get out of the contract if you want to rely on the doctrine of impracticability. Again, we need to be working towards settlements on these things. And I got to remind everybody, if we go to court, nobody gets paid, including me, by the way, because I'm not a litigator. My litigation team will get paid, but not me. So the goal is to keep these deals together. The next doctrine I want to talk about, Crystal, I'll get to your question in a second. The next doctrine I want to mention is frustration of purpose. If there is an unforeseen event that severely undermines the original justification for entering the contract, you may be able to get out of it under frustration of purpose. Again, I think it's a hard argument to say that Southwest Florida in hurricane season, a hurricane is unforeseeable because you can contract for it. And in fact, we discuss hurricanes in both contracts. So whether you can get out of it or not, I don't know. It's up for the judge and jury, and I would not want to risk it. I would want to settle and deal with it in an amicable fashion as best as possible. Okay, Crystal is asking, who determines the cost of damages, and if it goes over the or under the 1.5%, does it have to be an official contract or insurance estimate? Crystal, it's got to be somebody licensed to do so. I would argue that an insurance adjuster is a person who could do this work, although my preference is for you to use a contractor. Okay, all right. Next question. Christina is asking, so in Nabor, legally a seller does not have to allow for reinspection or mold, only walkthrough? No, Christina, that was a question under FARBAR. Please be careful. Under Nabor, you get a post, I didn't mention this, I apologize. You get a post casualty inspection in the Nabor contract. But the question is whether you can do it after the closing date. I would argue that yes, you can. So because the closing date would be extended for a few days to get it all done. The problem with the Nabor contract is that time is of the essence for closing, as we all know, and anyone's taken my classes has seen. But again, it says, let me share this again so you can see it. Where's the post casualty walkthrough? Here it is. Post casualty inspections. Once the property is safe, you can do a walkthrough to see what the damage is and identify the damage. And the seller, again, if it's has got to fix it under the Nabor contract. But that is not including association property. Noella, you only have to draft an amendment. It's not an addendum. It's an amendment to contract if you're going to go past the 7 days. FARBAR gives you 7 days automatically, and Nabor gives you 5 days. So just be careful under whichever contract you're under. Okay, questions. Feel free to unmute yourself and shout them out or put them in the chat. I'll answer them as best I can.
I have a question.
Yes,
We're supposed to close as is FARBAR contract on the 30th financing. The property is flooded, it's inhabitable. And my client's sellers filed the claim on the 29th. So there is no way that mortgage company will give the money. So do they have to extend the contract? Do they have to cancel it in 7 days after the 7 days counts since the title company is open, which was flooded also? And
So Valentina,
I-
under FARBAR, Valentina, you have to look for the amount of the casualty loss. Did it exceed 1.5% of the purchase price, or do you know yet?
It exceeds probably everything because it was under 400, it was 371, the purchase price, and the house is like in ruins. It's even not just flooded, but it's tilted towards the backyard now because they think that it was more water on the back of the house, so it's not leveled anymore.
So it's definitely more than $5,565 worth of damage, which is 1.5% of 371.
Yeah, it's absolutely that.
Then the buyer can terminate.
But do they have to terminate
They don't
7 days?
have to, they can elect to take as is, or they can terminate and get 1.5% of the purchase price as a credit.
So the timeline, where we 7 days, when it starts counting after the
Well, the force majeure,
hurricane?
well, no, Valentina, the force majeure event passed on the 28th, so that was 7 days ago today.
Mhm.
And services became available, I would argue, on the 30th. So you have 2 more days for force majeure, but you're not under force majeure. You're dealing with the risk of loss provisions of the FARBAR contract. And so there is not a day time limit in the risk of loss provision. The seller's got to provide the property as is, as of the effective date, subject to the casualty loss and the 1.5%. So if the seller, say for example, the seller could repair for 1.5%, then you would either repair or do a credit of up to 125% of the repair cost, not to exceed 1.5%. But in your case where it does exceed 1.5%, the buyer either takes as is and gets the 1.5% as a credit, or they terminate. And there's not,
Okay.
I wouldn't worry about 7 days. I would just negotiate either the termination or the going forward as is.
So the problem is the buyer is actually lives like neighbor in the same neighborhood. So he is probably dealing with the same loss of everything. Cars, like, I mean, the whole neighborhood was flooded.
Yeah.
So I'm just, I haven't heard from the buyer's agent at all, and I don't know if it's because he doesn't have a communication, if the buyers has no communication.
Well,
So
I see what you're asking. So I'm looking at the contract, and there's no timeline for dealing with the risk of loss. It just says, prior to closing, the property is damaged, then you go through this. So, I mean, you could argue that the time is of the essence for closing, and there was 7 days, so they would have to close within 2 days if they don't make this election. I mean, that's a possibility to argue that. But again, we should be trying to work together on this. And Maria is asking, can the buyer renegotiate the price in your situation? Maria, the buyer and seller can always try to renegotiate the price, but they have to agree to it. So
Yeah.
anything, 2 parties can agree to whatever you got to agree to it.
So I have another closing that have been like, it's a condo and it didn't have any damage, and they have a financing too. So we, like, the buyers actually had the chance to go and look at the condo, and they're going forward. But now the mortgage company is holding the deal because they are expecting it to close instead of the 27th of September on the 13th, because they are sending appraiser to verify
Right.
everything.
If you got a finance deal, there's a 99% chance that the lender's going to want to send out an appraiser to review the property prior to closing. And again, if they can't get out there within the 5 or 7 days, then we're going to have to work together and renegotiate these to get them closed.
So
as the
do you,
appraiser,
would
you could argue, I suppose, that the backed up appraiser is part of the storm event, but I'm not sure about that either. I would say we should be working as quickly as possible or negotiating extensions.
So we actually agreed on everything. Nobody, like my sellers is like fine with everything. They will let the appraiser in, the buyers is fine, but do we really have to do this legal paperwork? Or if the like mortgage company already preliminary said that
Yeah, I would,
they will get
Valentina, you
everything.
need to do written extension. Remember, everything in the contract has to be in writing. So
Okay, so
I would get something DocuSign to do an extension if you can.
okay, so even if everybody is in agreement and the title company is working with the financing and everything else, they still have to have a new extension saying that the new
I
closing
would
is.
say for safety's sake, as things change on the ground, I would do an extension, yes.
Okay, thank you.
All right,
Hey, Sam,
okay. Who's talking? Yes,
this is Wade Abid.
hi Wade.
How you doing, Sam? Hey, so I had a closing on Monday, the 3rd, that got stopped. Title company was closed. The buyer is in Connecticut. He also happens to be a broker, so he understands force majeure. He's making it back down here, and I've already communicated with the agents, the other agent, broker, that he would be back down here on the 12th. First flight he could get into this area. And everybody's in agreement. I drafted an not a modification, but a document to
An
just cover
amendment.
that.
Yeah,
An amendment, exactly. And we're all in agreement. He's going to be here on the 12th, well past the 7 days.
I would get it in writing. Make sure.
I
everybody
did.
signs.
Yeah, I did get it.
Okay,
So we should be squared up on that one, I think.
yeah, I think you're going to be fine.
And then one
That's an
other question.
That's an example of working together that I'm trying to encourage everyone to do.
Yeah, no, I hear you. And then the second one is we have one closing on the 11th, which I don't think will have any play in this, but we have one that's under contract and the inspection got pushed back. We had a 10-day on a far bar as is. We're going to get it in the inspection the day before the 10th day. Hopefully we'll have the report back, but the fact is it's happening on Friday. Hopefully we get the report back quickly. If there's issues, that takes us to Saturday, which goes to the 11th day.
Okay,
So what if we have issues? Should we just get an extension of the
again,
inspection period?
I would work out an extension of the inspection period on that one as well. Yeah,
Yep, good. Okay, that's the end of my questions. Thank you, Sam.
thanks, Wade. Okay, we have a couple of chat questions as well, so let me just go through these.
Can I ask you some questions?
Sure, Nanette, go ahead.
Hey, I have three. One, so this particular one, I'm thinking about the 1.5% over amount where they can get out or not get out is $20,900. We have a pool cage where I actually got a guy to do an estimate yesterday for me. It was 40,000. Okay, so that's without the tree issue. But the neighbor's pool cage that just got replaced, they sent me the seller's estimate. There's a big discrepancy. It's like 19,000, so we're like, I guess when we get a third estimate, when you go to decide what's that true estimate or where it is that cuts off that determines if they're over the 1.5%, whose estimate do you go by? Or do you get another impartial one? Or like, how do you decide?
Is this a far bar as is or what contract?
It's far bar as is, yes.
So the far bar as is does not contain the language that the regular far bar has for saying that the third estimate that was selected by both parties estimators is the one that controls. So now you're just negotiating. You
Yeah.
just got to work it out with the other party as best you can. If not, then those experts will all get on the stand in front of the judge in a year and fight it out. So let's avoid that. If
Okay.
you got three estimates.
Right now we've got
You-
two. One is under the amount, one's way over the amount. So we're gonna have to just pick one that we both agree on for the third one and see.
I would say even if you average them, you're going to be over the amount. Is that correct?
Yeah, that's what I think. Yeah.
So you're probably over. So the buyer can either take the 1% and negotiate with the contractor, or,
Yeah.
sorry, the 1.5% negotiate with the contractor after closing, or they can terminate.
Okay, my second question is about the, so when you, and this is the same contract, FAR as is, you said they're not really entitled to do another, anything but like a walk-in or a walk-through.
Walk-through inspection, right?
Okay, well, my people or the sellers have actually agreed and we've got another complete inspection scheduled. Now, this house right now still to this day does not have electricity. The beginning inspection that happened 3 weeks ago, there was no issues with mold or anything. They're agreeing to let us do a mold inspection. If it comes back now that there is mold, since the original inspection showed the house did not have mold and they have to give it to you in the same condition, will they be responsible for replacing the mold if the second one shows up with mold?
Yeah, so I would say this falls under the risk of loss, the casualty loss provision of the FAR as is. And the sellers they have to spend up to 1.5% of the purchase price again to remediate the mold, because you got to remember that the FAR and it says that the seller passes the property as is except wear and tear or casualty loss. Then when you look at the casualty loss provision, it says that the seller's got to spend up to 1.5% for restoration. So
then in that situation, the seller would have the option to walk away if it's too expensive.
no, if it's too expensive, the buyer has the option to walk away or take as is.
Okay,
But if it's not too expensive, then the seller must repair.
but if it's past the repair of the of the 20,000 for whatever reason, and the buyer
Then
wants
the
to
buyer
stay.
takes- Then the
But
buyer
then
takes
they would
as
have
is.
to take it. Okay, gotcha. And then my last question is about the date of when the actual force majeure period started. I called my broker yesterday and he was saying kind of what you did. It's kind of gray when that actually started. And in his opinion, he thought it started Monday of this week because that's when banks officially opened and da. So when I called the seller's agent, we kind of talked about it out loud. And in our minds, we counted the 7 days plus the 30 days to get everything done starting yesterday. So we've kind of agreed on a date. Is that okay? Or is there an official date? Because I don't want to like have them pass a day, and because we were supposed to close October 25th. So
So citizens started writing insurance again on the 30th. So that
Okay.
would take you to the 7th under FAR for 7 days force majeure. But again, you're gonna have to work with everybody because it's a question. Like, for example, we lost internet and we lost power, which means we lost internet, which means we lost our phones and all communication means on the Wednesday at 2:00. So is that the official time for the start? No, it's actually after the event passed. So this hurricane passed Naples. I'm sorry, I haven't slept much. My days
no,
are
I get it. No,
blurring
it-
together. It was
Yeah.
like Thursday night it passed. So and citizens started writing again on Friday. So if it's 7 days after the force majeure event no longer prevents performance, and you could start getting insurance on Friday, I would argue that Friday is the first day. So
I guess though, if me and the other girl both in our heads, like
yeah,
now the people think it started Monday and they agreed to that, is that
I
kosher?
would again reduce that to writing. An amendment to the contract, just get it written down. We all agree that the force majeure event started Monday. 7 days takes you to the 10th. You know, you can put the inspection is going to be the 11th and the parties agree to allow it to go through. If you want, again, by the way, I forgot to mention this at the beginning for everybody. I'm happy to help. If you need stuff reviewed, if you need amendments drafted, I'm not charging right now. I'm just getting it done. Just shoot me an email. I am on email as best I can with the hotspot. Obviously, I'm up online right now. So if you need things reviewed or drafted, email me, sam@sodlegal.com, and I will help you. Just
Because I did do it
get
with
it
an
done.
email. Yeah, okay, I did send her it's there but it's not in a contract or an amendment. So, okay, I get it. All right,
Yeah,
that's it.
I would get it. You got to get stuff in writing. Remember, guys, contract states, both FAR and Nabor, it has to be reduced to a writing.
Gotcha.
So And again, I will happily help you. So whatever you need. Let
Thank
me
you.
get
Sam, I have a
everybody-
question.
Verna, 1 second, Verna, I
Thank
got a
you.
bunch of questions in the chat, then you'll be next.
Thank you.
Okay, oh, this is from you. How do you handle the execution of contractual changes when the buyer and seller do not have internet access or the ability to sign personally? Verna, if you can't get them to agree, I mean, you're their agent. If you had some level of authority, and if the realtors or those closing agents or the attorneys can get together and just agree to extend till they can reach their customer, I think a court would hold that up. I can't say for certain, but if I am your attorney and I can't reach you, but I know that you want to close, I will negotiate the extension and sign on your behalf. And if I'm wrong, you'll sue me. But
So I have I have to list the seller, and the buyer's agent and I have spoken. The buyer's agent has spoken with her client. I've spoken with my client. Everyone agrees verbally, but no one has the ability to e-sign or to sign.
can you get an email to the other agent and exchange emails that say we all agree to extend? That's the next best thing.
All right, thank you very much, Sam.
You got it, Verna. Okay. Who's this? Could you send us a copy? Yeah, I'll send out the highlighted contracts in my email blast along with a link to the YouTube channel. Can the seller assign the insurance claims to the buyers? You can. That gets really complicated really quickly, but you can do an assignment of claim if the insurance company will agree. Most insurance companies, in my experience, are not really allowing that. So we'll have to work through that with the insurance companies on that one, Isabella. Okay, Mark is asking, my buyer is in a Nabor standard contract on a townhouse. She's getting a loan. Her closing date is this coming Monday, the 10th. Her lender is saying the townhouse needs to be reappraised for underwriting, and we don't know when the reappraisal is scheduled. If the reappraisal delays the loan, does the buyer have the right to extend the closing date? How many days can she extend it? So, very good question, Mark. If the appraisal is not going to occur until after the 10th, the closing date on the Nabor contract, pull up the Nabor contract. See, the Nabor contract gives an extension for CFPB compliance, and it does not contain, again, the force majeure pause that the FAR does. But if you go, it says the Nabor contract says that if the services are not essential for closing as a result of the casualty, then you can delay for up to 5 days after coverage becomes available and the services essential are restored. I think I would try and wedge this into that provision, Mark, and just say, we can't get a reappraisal right now. We have up to 30 days to get a reappraisal. I mean, I think that's how I might argue that if I have the buyer and I'm trying to protect the deposit. You can always go back, try to terminate and go back in once you can get the reappraisal. But I think I would try to get under standard D2E sub 2 and just say services are not available, Mark. Okay.
I have a question, Sam. It's Linda.
Hi, Linda, go ahead.
I have a contract that's supposed to close on the 13th. It's a fast pass loan, I guess, with Gold Star. So the contract Nabor was, they selected, cash, no financing contingency, because it was a fast pass. But I just got an email saying that they needed to do an appraisal, I guess, to come and check the property. But my seller can close. I mean, correct? They can't, these
Well,
people.
again, this is the same question I just answered, Linda, in a different form. The
Okay.
contract says services available for essential for closing need to be restored. I mean, is the fact that there's not enough appraisers right now, which is probably a service essential for closing? I would, again, if you've got the seller, Linda, tell your seller to work with their buyer because they don't need litigation that ties up their property while the buyer tries to figure this out.
Even
Remember,
though,
litigation is slow at good times. It's going to be even worse now that everybody's, right? Like, for example, right now the courts are shut down.
No, I understand that, but this is a cash, it's considered a cash offer on the contract.
Cash versus financing doesn't matter under the risk of loss provision.
Okay,
So, I mean, you could argue, you can argue that it's not essential because it's a cash deal, I guess is what you're trying to say.
yeah. Because it's a fair, you know, it's a cash deal. And they could choose to get financing if they wish under the Nabor contract. You're paying
Yeah.
cash, you can opt to get financing. I mean, it's a cash deal.
If your seller absolutely won't work with them, maybe, but I would say work with the buyers.
No, I think they would, but I mean, they need this money. There's nothing wrong with their property. It's perfectly fine. But they need this cash to purchase their other property that they're in
Sure,
contract.
and I've got 3 or 4 of those exact situations where people are dying to close because they had pending purchases in other places. And again, the short answer is we've got to all just work together to get it done. Okay, Joni is asking, is the 1.5% for each damage part of the property? No, it's 1.5% of the purchase price, Joni. 1.5% of the purchase price. In the next case, it was insurance policy enforced. Yeah, so insurance is going to be a major factor in all these. I see a lot of insurance questions coming up. You know, I readily admit I am not an insurance expert on homeowners insurance. So I would have you call your insurance agent and see what the assignment requirements are for the insurance contract, because insurance is just a contract with the insurance company. And talk to the adjuster. If you do not like the price that you're getting for your repairs, then I would call a private adjuster and fight back with them. If you need to hire an attorney, I would refer you to insurance counsel, and I have a couple of attorneys that are handling that right now. Okay. Delia is asking, Farbar contract cash buyer inspection was completed last Tuesday. All was well. There's a stain on the ceiling. 2 roof tiles are tacked. 1 is missing. Seller would be responsible to repair that, Delia. That doesn't sound like 1.5% of the purchase price unless it's a small unit. Debbie is asking, asking about whether Nabor is going to have a Hurricane or Ian disclosure. I don't know. We're going to talk about that tomorrow, Legal Resources, Debbie, and we will put something out as soon as possible. Okay. Wade is asking, currently the condo does not have water pressure due to broken water lines affecting the community. This is not in the condition the unit was in. If the community's broken lines are broken, Wade, you gotta have services to test the water, I would argue. I'm not sure. I would argue that if this is a condominium or an HOA, I would say that you gotta have services essential, test the water, try and get an extension. Let's see, Nanette is asking, if the boat dock is deeded and included with the sale of the home and is damaged, that amount count the cost of damages to the home? Nanette, you gotta look to the association documents, if it's a limited common element, or if it is a common element, then probably not. But you said it's deeded. If it's solely owned and the responsibility, then it probably could be included in the cost of the home. Okay. Alyssa is asking, my question is regard to the loan approval period on Farbar. Loan approval period expired yesterday, but the bank needs an appraisal reinspection. They assume a 7-day force majeure kicks in. If we're using the 30th, that'll be till tomorrow. That's true. So if the condo was not approved by the bank, so Alyssa, I'm having a hard time understanding your question. If you want to unmute yourself and explain it to me, go ahead.
Hey, Sam, can you hear me?
Yes, Alyssa, go ahead.
We had bank approval for the condo, but now they just need that reinspection to go out there. So since the force majeure, I assume, expires tomorrow, do we need anything in writing or an extension of the loan approval period?
Well, again, the force majeure and Farbar says that it's 7 days after the event no longer prevents performance. I'm working through these questions and I'm thinking to myself, if we can't get these appraisers out there because there's not enough of them due to the storm, I'm gonna start arguing that that prevents performance and they've got to pause the contract for up to 30 days. So if you've got people that need to get these re-inspections done and you can't get your parties to agree to an extension, then we're gonna make arguments under force majeure that we have 7 days after the event no longer prevents performance, which would mean that once we can get the property inspected, we can close within 7 days. I'm not sure that's gonna hold up, but it certainly is gonna put a lot of pressure on sellers to be agreeable. And by the way, remember, we're still kind of going into a down market. So sellers need to get their properties, who need to get their properties sold, need to be agreeable as quickly as possible. And I understand a lot of people were buying a new property and they need the money, but do you want to wait a few weeks and deal with that situation? Or do you want to go to court and wait a year or more? I mean, those are, it's the best of two bad choices right now. So people need to be a little bit more thoughtful in their, and understand their circumstance.
So we told the bank to get someone in there ASAP because there's no damage.
Right?
And so they're working to get somebody in there as soon as possible, but do we need to get an extension of the loan approval period?
I would ask for one if at all possible, yes.
Okay.
It says all time, the FAR bar says all time periods. If you look at lines 448 and 449, it's all time periods. So I would try to get one, but if the other party won't agree to it, the seller won't agree to it, I would make that argument that under this provision, you get what you need. You get the extension. Okay, other questions that people have? Not seeing any more in the chat. All right, everybody, it's 11 o'clock. I try to keep these to an hour so you can keep working. I am available by phone and email. I'm doing the best we can with no internet at the office, but I've got internet at my house. So I'll be running around. If you need me, please give me a call. I hope everybody is safe and didn't have too many problems. But we're here if you need us. I'll talk to y'all soon. Thank you.
Thank you, Sam.
Thank you so much, Sam.